As the Kyle Rittenhouse trial concludes its first week, it's tough to say what the prosecution's theory to substantiate the murder charges even is. Their case has rambled at length through the irrelevant, only to arrive at the self-defeating. They've undermined their case with their own witnesses who have testified that Joseph Rosenbaum, the first man shot, chased and lunged at Kyle in a threatening manner, trying to take his rifle.
So your interpretation of what he was trying to do or what he was intending to do or anything along those lines is complete guesswork, isn't it?
Well, he said, "F you," and then he reached for the weapon.
And testified that Rosenbaum overtly and explicitly threatened Kyle with death immediately prior.
Rosenbaum was right there in front of my face, yelling and screaming. He goes, "You know what? If I catch any of you guys alone tonight, I'm going to kill you."
Did he say that to the defendant as well?
The defendant was there, so yes.
They've undermined their case with their own video evidence, as we'll get to. That super secret FBI drone footage that the prosecution had said would change the case at a pretrial hearing does no such thing. In fact, it only confirms what we already knew, just at a much lower video quality. Rosenbaum chased Rittenhouse for a long distance well before the first shot was fired. And by the way, the first shot was not even fired by Kyle himself. They've also undermined their case with multiple lengthy and irrelevant total wastes of time, like just how much Skateboard Man loved to skateboard.
Even shortly before he died, when I would take him somewhere, he would know I was picking him up in a car, he was going to go home in a car, he would still have the skateboard in case there was a chance there was an interesting parking lot somewhere and he could go out and skate.
As though loving to skateboard means he couldn't possibly have hit somebody with it in aggression, or other pressing issues like just how a man could possibly stick to his mission of helping others while taking a snack break at a gas station.
I thought I heard you say that the purpose of going across the police lines was to see if people are hurt and to go check on the 63rd Street location.
That is correct.
Help me understand, how does going to the ultimate gas station and going inside fit in with that?
Because there were other people at the ultimate gas station.
Eventually, lunch was deemed far more relevant than the prosecution's case.
What relevance would his perception?
Because they're part of the same group and he's taken this responsibility and now they're in an area where there's a perceived need to protect the defendant.
Well, why don't we take a break?
But while I haven't seen anything so far in terms of evidence or even theory to substantiate the prosecution's burden to prove beyond a reasonable doubt that Kyle acted anything but reasonably that night, that's not to say that the trial has been without any important revelations. Even if the evidence isn't showing us anything new, how that evidence was acquired and how some of it wasn't are both important new facts in the case. Part of the reason we aren't learning much new in this case is because so much of it was on video. From the moment that Joseph Rosenbaum initiated that chase of Kyle all the way through Kyle's attempt to surrender to the police, almost every moment is viewable on video, often from multiple angles. And part of that is because the people who captured that footage posted it themselves and surrendered it to investigators themselves. And another part of that is because the investigators got search warrants to recover the data from those phones if the evidence wasn't handed over voluntarily, including from Kyle Rittenhouse himself, by the way. He voluntarily surrendered the contents of his phone after the Kenosha Police Department and the FBI tried to crack it and couldn't. Kyle and his lawyers just handed over the passcode, asking only for a copy of the data to hold for their own records. And something similar happened with everybody else who was recording relevant footage that night. Investigators were firm about requesting to download phone data from anyone they questioned. If consent to do that wasn't provided, police would get a warrant to recover the phone data and thus any video, photo, or other evidence relevant to the case. And that's exactly what happened for multiple people. In fact, pretty much everybody who police questioned after that night in Kenosha. This according to witness Detective Martin Howard, the lead investigator on the case for the Kenosha Police Department. Everyone except for one guy, that is, and not some fringe character either, a guy very important to the case. The only identified guy to engage violently with Kyle Rittenhouse and live to tell his story. Gage Grosskreutz, the revolutionary whose fist can no longer raise on its own and needs a capitalist support structure in a metaphor that's way too on the nose. As exposed by defense attorney Mark Richards, when investigators questioned Gage Grosskreutz, they simply let him walk without providing any of his phone data, even though they had the search warrant to compel the surrender of his phone data.
Search warrant in one hand, correct?
Yes.
Telephone of Mr. Grosskreutz presumably in Mr. Grosswitz's hand.
Yes.
And for some reason, that search warrant was never served on Mr. Grosswitz and his phone taken, correct?
Correct.
Obviously, the natural follow-up question is why? And Detective Howard said there were concerns about potentially violating a new addition to the Wisconsin state constitution called Marsy's Law.
Do you know why it wasn't executed?
Concerns with Marsy's Law?
Marsy's Law refers broadly to a victim's rights law. Various iterations of this law have passed across several states, including Wisconsin. These are, in general, laws that protect the rights of victims of crime through several different means. Relevant to this context, the Wisconsin law protects the privacy of victims of crime from overly intrusive records releases. Say somebody breaks into your home and assaults your family, and then a news reporter submits a records request to police to get all the details of that attack. Marsy's Law in Wisconsin may protect your family from having to release overly personal information. But there are several problems with applying Marsy's Law in this way in this context. Number one, Gage Grosskreutz was not an adjudicated victim. No court of law had determined that he was victimized. That was simply the speculation of police and the prosecutors. And not only was there no conclusive reason to believe that Gage Grosskreutz was a victim, but there was reason to believe that he was an aggressor. Not just reason, in fact, but evidence. He's on video pointing a gun at Kyle's face after Bluff surrendering. And this before Kyle shot him to defend himself. Number two, Marsy's Law, as far as I understand it, and as far as the Wisconsin Department of Justice describes it, prevents the release of information and evidence to the public in certain circumstances. It's not a law that prevents the gathering of information in investigation, particularly information for which a valid warrant is signed. And these factors combine to form a third oddity. This never happens. Detective Howard says he's never declined to collect evidence for a Marsy's Law reason, except in this case. And since this case, he never has again.
Have you ever not executed a search warrant because of Marsy's Law?
No.
Since that date, September 24th of 2020 to today, have you ever not executed a signed search warrant by a judicial officer of Kenosha County because of some concern of Marsy's Law?
No.
And by the way, the refusal to collect that evidence isn't for something hypothetical. It's not about photos or video or other records we think may exist. We know they exist because Gage Grosskreutz was streaming from his phone that night, following Kyle Rittenhouse closely immediately before their violent altercation. There is, or was, evidence on that phone that is relevant to this case that remains unseen for this totally bizarre and unprecedented reason. And the odd and unique benefits afforded to Gage Grosskreutz go beyond just this deferential treatment of his phone. His interview with police itself was also treated unusually. Everybody else had their police interview recorded. Dominic Black, Kyle's friend who gave him the rifle. Richie McGinnis, the Daily Caller video editor who was immediately beside Kyle and Joseph Rosenbaum when Rosenbaum was shot. BG on the scene, who also captured much of the most significant footage of that night. They all participated in recorded police interviews except the man with the flying biceps.
When the interview was performed with Mr. Grosskreutz, that interview wasn't taped.
I don't believe so.
In the case of the interview not being recorded, no specific reason was given for that special treatment or irregularity, but in the context of the refusal to collect the phone data, Detective Howard says that was at the concern and advice of Thomas Binger, the assistant district attorney, in fact, the very prosecutor leading this case.
Who had the concerns with Marsy's Law?
I did. Attorneys did.
When you say attorneys, you're talking about Attorney Binger, correct?
Correct.
And complicating the relationship between Detective Howard and the prosecutor Thomas Binger are two more factors. Number one, the two had worked together to offer a deal to that reporter BG on the scene whereby marijuana found on his person would be excused in exchange for access to his phone. There's nothing wrong with prosecutors and police making deals with involved parties in exchange for evidence, but there is something wrong with not disclosing that deal, which the prosecution did not. And funny, right in the midst of his cooperation with all these unusual and potentially corrupt investigation practices, Detective Howard was made lead investigator on the case. This was a guy with, at the time, less than 2 years of investigatory experience, now leading the most important and high-profile case Kenosha has ever seen, right after some shady investigative practices happened. Sounds like an awfully good deal made out of considerations for things probably beyond who was best for the job. And all of that is only part of the evidence that was mishandled in this case. But the other was the handling of the FBI, so naturally, that is much less surprising. During a pretrial hearing in September, the prosecution had hyped this FBI drone footage they now had in possession that supposedly showed that all the other video gave an improper understanding of the case, that actually Kyle Rittenhouse had been aggressive with Joseph Rosenbaum first. Kyle was the initiator, this video supposedly showed. On Tuesday, that video was finally revealed publicly, not by the prosecution first, but by the defense in opening statements, because it shows no such thing. In fact, it only shows what we already knew. It's a very poor quality video, but here's Rosenbaum running down the street ahead of Kyle, who is also moving down the street. Rosenbaum then hides behind some cars, and as Kyle passes, Rosenbaum jumps out and chases him, all of this immediately before the two run across the lot, and Kyle is cornered and shoots. The prosecution's claim is that Kyle was chasing Rosenbaum aggressively.
What's clear is whatever that confrontation that was initiated by the defendant, it caused Mr. Rosenbaum to come around the cars and start running after the defendant.
If so, they'll now have to explain why Kyle's reaction when he finally catches up with Rosenbaum is to run away as fast as he can, as the video shows. But the controversy here isn't just what the video shows or this preposterous stretch of an interpretation of it. It's also why we never saw this video before and why we're only seeing it now in a limited format. Obviously, the question asked back in September still stands. Why did the FBI hang on to this footage for a year and make no mention or release of it other than to the prosecution specifically? Not to the police department, not to the defense team, just the prosecution. And I thought you guys were the FBI. I thought you had the coolest and best spy tech around. So why is this footage of such poor quality? A pigeon carrying a flip phone probably could have had a better look. Of course, the testimony of the FBI agent present at trial to explain all of this was not broadcast for reasons not explicitly stated, but according to sources within the courtroom, the FBI possessed both low-res and high-definition versions of that same video, but again, for reasons unexplained, the FBI simply lost the HD version. Reportedly, the judge was aghast at the explanation that the FBI had just tossed away evidence relevant to a homicide case, but you can speculate why they might do that. One commenter says that in the HD version, you can see the FBI badges glowing green in many of the rioters' pockets, so we can't have that seen publicly. Was it simple incompetence? Was it something intentionally nefarious? Does it even matter? Because neither one is worthy of your confidence. Either the FBI lacks the skill or they lack the honesty necessary for a trustworthy reputation. And no matter what happened to that HD version of the video, all of it was sat on for a year's time. What happened with this FBI recording is largely emblematic of what's been happening at the trial overall. Desperation and flailing in a way that defies standard protocol and honesty, but still totally fails to build a compelling case anyway. If you're going to toe the line of cheating, at least have an awesome win to show for it. The prosecution is well on its way to the shame of both playing foul and losing for the effort, the ultimate embarrassment. But of course, that would assume that we're operating in a world where truth, justice, and the impartial application of the law win the day. And as we've seen in trials past, and we'll see again in trials future, and perhaps we'll see in this trial present, political preferences can influence and excuse just about everything else. I've made the mistake of thinking incompetence and dishonesty predict a failing case before. I won't do it again. Like most other contexts these days, I assume less and less is accident, and more is strategy. And I know we're supposed to assign stupidity before malice, but I'll assume stupid accidents again when stupid accidents start properly failing again. Only then will they get the benefit of my doubt. As long as stupid accidents keep winning, well, then they probably aren't stupid or accidental. Thanks as always for listening and for supporting this channel always. Appreciate that thoughtful discussion down below and especially over on Gab, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.